Okay, good afternoon, everyone. Thank you for joining us for the second of our Wednesday seminars, Problems and Solutions with Subcontracting, which Henry is going to be sharing the benefit of his wisdom with us to deal with this afternoon. As always, if you could submit any questions via the Q&A facility in the bottom toolbar, and then Henry will address these at the end of the seminar. So thank you very much, everyone, for joining. And Henry, without any further ado, over to you.
Yeah, okay. Good evening, everybody, and thanks very much for joining this evening. The purpose of this is quite simply, as you can imagine from the title, is to sort of concentrate on a sector of the business that, quite simply, I've always seen as quite in a risk area in construction, in the industry. And that's actually going to be more so in the next couple of months. The type of squeeze that we expect to see, like the general feedback I'm getting from quite a number of companies, is that pricing quite a lot. In fact, some companies have been saying to me, or clients in general reach have been saying that they've never priced as much in the last number of weeks, but the strike rate, of course. So this is going to start leading to numerous different issues. Okay, like no, it doesn't necessarily mean like no, that's foreseeability, I suppose. But if there's that many tendering, we are now going into an environment, especially with subcontracting, especially with SMEs, and any large-scale development or any large-scale project, you can generally expect that 80% of the work, 80% of the value, all will pass through subcontracting units and entities. It's a significant amount of money that flows through the supply chain, and the interruptions that usually happen, and the rate of insolvencies, and quite frankly, the amount of corporate insolvency I do, generally in terms of trying to rescue or otherwise. What we have seen, and certainly I've started seeing quite numerous different elements coming through, more and more cases of a particular type in around late last year, early this year. And of course, keeping the eye on the statistics, how that was actually surrounding. And it tells you quite a lot, because whatever about people blaming coronavirus for quite a lot of the different points now, this is a heavily stressed industry anyway. And I think that there's 3,077 insolvencies in the construction industry by the end of last financial year. And that's even pre-COVID. So in this instance, we're looking, and the real risks are facing now with subcontractors, the supply chain, especially like with the amount or the type of issues that they actually stand going through. We've got one large tier one at the moment that's talking about restructuring quite an awful lot. They see it as very much stable though, because it's a government public schemes. And that's very much on the public radar record at the moment. But in a contracting market. And the real difficulties seem to be as well to suggest, well, if we are now looking towards all of the work elements that are happening, if we are now going to impose points of social distancing, we already recognize the difficulties in suppliers at this stage as well. Is there going to be an increase in actual materials, or what's the type of cost, like labor, of course, most likely will have to marginalize itself. But in general, how accessible or how quick or how expensive is it going to be, either quietly or ancillary wise? But if that's the case then, and then we're now into a market where we've already started hearing that a lot of people are pricing a lot of work, and there's quite a lot of different elements of tendering on different projects. Maybe I'm wrong there. From many people listening to me, they probably say that they're not tendering enough at all. But certainly it's only what I've heard in the last while. The real issue then is this is an industry, rightly or wrongly, that decides the subcontract on the price elements of it. And it's just real bottom line, and no matter how much it's debated about whether it's right or wrong and all the merits surrounding it, it's really hard to imagine that going into a particular project when there's so much competition or tendering happening on that to actually on one that is contracting or the expenses. And remembering as well that in any ordinary environment, it's difficult enough to estimate. And I remember even from my own construction days that like any time that large tenders were won, the only person not celebrating was the poor estimator, wondering what mistakes he must have made to actually have won the project. So if that's in the times that were pretty certain, like that you could understand, well, we've now got these uncertain times and costings or how they're costed and all of these points. And that's only in the initial stages. That's only getting into the contract point. The next thing is the operation of it. Like, how does the disruption get costed, or the rules of contract are not going to change. In fact, what we're seeing post the lockdown period of time is really that the essential elements of the contract really are coming into play. So where everybody was hinging everything on a force majeure, and that became a very famous term. Like, even past that, the issues surrounding causation of disruption, the parties really understand how these elements all sit in. So new contracts, and it's going to be very simple. I don't think anybody would need for me to suggest and say on this. It's a pretty obvious term to say that any new contracts will need to cater for a pandemic or even more specific point of either second waves or how the contracts are to actually be managed in those. And they're going to become management, because the element of foreseeability is well clearly there. So it has to be addressed. So you can forget about any far-flung ideas beforehand. So that's the reality. But what isn't certain at all is in a very much a cash flow really dependent, and that's the difficulties. So with all of these flows, and then of course, we have this complex sort of array of system with so many different parties. And I think one of the privileges of being a lawyer working in this is knowing and acting and having access to all the different elements, from the funds to the any other beneficiaries, to the consultants, main contractors and subcontractors, or subcontractors. But of course, we have to watch for the upline insolvency, or the routes where we're actually now suggesting that if there is a party that becomes insolvent at a certain point up the line, how does that affect those underneath, where there is quite considerable value? So that's that's, if anybody realizes it, that's section 113, which ostensibly, of course, is the outlawing of the pay when paid. But of course, it goes further to upline insolvency. But underpinning all of this, and really in general terms of why the importance, all of these things come back to a matter of the construction of contracts. And in any events, I will always describe and discuss the sort of first principles. If we don't have the elements of the construction contract, and before we even go into the standard form contracts or how they operate, we've got to get a real clear understanding. Quite rightly so that so much money is spent on elements of, say, health and safety, and it has been for years. And quite right, in terms of what the points are. But my instance is that companies certainly haven't looked to say, well, we should be actually getting the level of education, level of training within our broad company to ensure that we actually don't hit the problems of the future that we think are going to hit. We generally, trends and patterns always will show we're not going to face any more than 3 to 5 distinct issues in any given contract that leads to a dispute. It's generally always about 3 to 5. There's not really much more. Anything else, you're really looking at sub issues of that main issue. So if we get a really good handle on how to handle those different issues each time, and knowing that every single time this is how your business runs. And the test here is that if you get any of your people in your companies to look over the last 5 projects that you've actually been involved with and problems that have arisen during those, you're going to find that they're quite common, and they're going to repeat themselves. So the responsibility there is to say, well, if what do we have to do to that, either to prepare, or how do we circumvent those, or how do we manage those or de-risk those? And that's really where those points come true. So the really instance. So just before I start, but what we would actually look towards, where it all goes wrong is when you get a case like RTS Flexible, which ended up in the Supreme Court. So you can imagine the different hierarchies of the court structure before it gets to the Supreme Court. And that was actually on the basis of the formation of the contract. And, a couple of different things that we hear. These are not social contracts. They are not sort of like, to leave it to the instance of how much do we actually decide is the certainty. And this is about evidence. This is about, certainty of terms. And this is about being in a position, why spend an extraordinary amount of hours, an extraordinary amount of money to try and prove something that quite simply could have been dealt with at the very, very start. RTS Flexible is a perfect example of huge amounts of money in construction context where the parties haven't agreed terms. And the real question was, what is the contract? And is there a contract at all? And this is before even divergences between different terms. So real first principles. It's got to be said as well, if we're contracting on purchase orders at the moment, we're going to have problems. So why, what are the terms that we're actually contracting on? What's the expectations? What do we actually deliver on those different points? We've got to get out of habits that, the very moment a set of terms comes over by main contracting, that instantly either A, we just sign it immediately thinking, well, it's never going to happen. It's never going to exist. That problem, or, farm it out for whatever type of money as some type of insurance policy, get commentary on it, do our best, but still not understand what actually is in there. If we understand a contract to its best ability, the agreement is what the parties intend to carry out, what the expectation reliance is at the very end. But realistically, the terms and conditions, what they are is the conduct of the parties to reach that. So if that is completely divergent or it's in direct conflict with how you operate, that's the first warning sign. And in that respect, especially if we're going into very low margin, we're going into high risk elements as well, and I would deem where contracts have been just priced off schedules of rates, of averages, without understanding the actual project or the sequencing, etc., would be that is introducing a risk in itself. Okay, so if we look at the formation of simple contracts, it's going to be critically very straightforward. Okay, what you need, and this can happen at any stage. If you have, it is possible in certain instances to be working throughout a contract and to actually form another agreement, actually, or is there a binding agreement? But we need those essential elements: the offer, the acceptance, consideration, the intention to create legal relations. But ultimately, if we're in a subcontractor position at this moment in time, we are actually suggesting that the contractor providing the tender documents or the pricing documents is not the offer. The offer actually comes from the subcontractor to the contractor in this instance. It's capable of acceptance. Now, that offer can be withdrawn before acceptance at any time. And these are real basic first principle points of contract law, but they're important and they underpin, and they will always raise their position, no matter how complex the difficult arguments come through as well. But there must be there must be consideration. That's a rule in terms of, say, especially common law, where there has to be something of a promise in itself is not binding or enforceable. So therefore, like, we're looking at something to the detriment. So we've got the points like for £1, whatever like that. But there must be an intention for both parties, and that can be a matter of how the facts run through. But in construction contracts, it's not unusual for parties to enter into a period of negotiation where offers may be accepted and part work start where it is assumed there is or will shortly be a concluded contract. The approach of the courts is the contract will be found to exist if the parties have agreed on the essential terms. So this is the real danger zone at this moment in time. And I must think back, obviously, to one of the most ones that always comes into mind so long ago, and certainly that it's quite safe, but it's where it would often be said where a subcontractor would suggest to me that there is no contract. They haven't entered into a contract. There's no contract between the parties, not necessarily right or true. The ability, the courts will strive and they will work desperately hard to ascertain what the contents of a contract are. it's very unlikely that anybody does or take works gratuitously or in a charitable sense. Might do, but it's unlikely. So in that instance, there certainly would be an agreement. The only thing missing is how or what the terms of that agreement was. What is the actual dispute? Of course, when contracts are said not to be signed, well, that's not clearly going to save a party either. If parties have started to conduct themselves, one of the real indications of binding by conduct is performance. It's you've started carrying out the work, and moreover, if you've been paid for that as well, that is going to be pretty conclusive that there is agreement, that there is something there between the parties. The key question left is to say, what is it? What are the elements that are missing, and what constitutes it? So the different points about is, who are the contracting parties? This sounds very, very straightforward. It's pretty critical and it's pretty important. Who is your client? Who are you working towards? This becomes, and one of the reasons why is because, what really matters with companies, especially on Companies House and any type of due diligence, is what is the nature of the company? We want to look and we want to be pretty certain on what the company number is. Names can change pretty straightforward. It's not that difficult to change the name of Companies House, okay? But names can be very, very similar. They can put just in a title into brackets or something like that. But it's essentially, it's not that actually difficult to actually understand, to change. So always the company number, registered address, but that will give a lot of different hints onto what parties are. In that is it an SPV, is it carrying any assets, but essentially to name that party, especially if they're in liquidation. And there has been many, many instances where it has been difficult to ascertain what party is actually contracting with who. And if we can't get over that threshold, we've really created a problem for ourselves. We really have, especially where there's different companies using different emails, who's paying who, whatever in those instances. But it becomes actually more of a problem than you think it would be. The scope of the works, so the remaining points of, who, and it's often been said, and we've had lots of different cases, really going back into range, like even when I think back to sort of multiplex as well, Cleveland Bridge, of course, as well, British Steel. These are the type of cases that always come to mind in relation to these type of arguments. But what have the parties contracted to do, and for how much? And what are the express terms? And therefore, do any terms need to be implied thereafter, either by statute or to make it work? And that won't be actually done very, very easily either in that respect. So these are the kind of problems, but we see them more often than not. We see them, and what we actually see when these ambiguities actually arrive, that's when people feel threatened. So the more ambiguities there are, and especially if you're not in a position of strength, the less ability you will have to actually assert yourself or stand up to what is probably right. These ambiguities, they create those threats. Those threats then create doubt, and those doubts then amass themselves to get into a really, really bad agreement at the end. And it can be absolutely devastating. But again, these are negotiation points at the end or throughout, and the difficulties of those. And it all hinges upon lack of certainty on these instances. So what's the position where there's no binding contract in itself? It's common in the construction industry for the contractor to place an order with the subcontractor on its standard terms, only for the subcontractor to accept on its own standard terms. So further negotiation follows. Correspondence is exchanged with regard to agreement of terms, where some may be agreed and others not. And in the meantime, the subcontractor starts work. So essentially what we're trying to describe here, which we see really quite a lot of, and the reason I spend so much time in the SME market, I suppose, is because the amount of time I've actually worked within the SMEs and broad scale, even in engineering, but I've always, throughout the last 18 years, seen so many different problems actually generating around the lack of sophistication in terms of how to crystallize this or the definitive. Not every one of these contracts has that crystallized wonderful document that's signed, executed under witness, and properly delivered as a deed or under hand specifically, that is completely complete with clarity. This is this is one of the real big issues with the industry as it faces. And it stems right from the very start, 4 to 5 weeks for tendering so I really do, I empathize, I sympathize with the question when it comes back to me on that point to say, how do you expect us to get into a full agreement, know exactly what's happening when we've only had 4 weeks and they wanted us to start? We always thought we were going to complete it and get to the certain point of certainty. The very moment the dispute occurs or some tensions arise, you've lost that ability actually to agree, because you're now into a dispute. It's going to be very unlikely to agree anything. You're now into a dispute area. But we don't always have the benefit of those. And I do appreciate that the short space of time of tendering, not fully understanding, which in itself doesn't sound right, even as I say it. And of course then, not having that crystallized contract in the end. It is more prevalent right where the money is flowing in the lower tiers of the actual organization chart of the project. It's much more prevalent. When we talk about, say, funds, and we talk about employers and main contractors, that's been negotiated over months in some instances with wonderfully engrossed documents. That's happened over time. That's certainly had its ability. They're very well developed. And, you know, quite simply, even I have to say as a lawyer, you know, in consideration of the different times that working with subcontractors, I even get more time as a lawyer working on the different fund agreements or the agreements for lease, or I get more time even on the development between the employer and the contractor. Not a vast amount of time, but when compared to those, and this is the timeline, this is what's been forced upon it. So we're now into this area where actually we get the subcontractors who are starting at some instances before the terms are fully agreed. We have subcontractors who are bound by terms by the contractor, but then they have their own supply agreements, which are completely at odds. So, you know, a subcontractor gives their terms to the contractor, but the contractor has their own terms, which are going to take precedence. We're now into a position, like, you know, realistically, where we're going to be talking about the battle of the forms. But what are the general principles to be applied? Generally, the last letter is deemed to be accepted if the other recipient then starts or continues to work. That's not as easy as it may seem. Like, no, but it's when the performance. So we're in the last shot doctrine. That's what this is called, last shot theory, because all of the offers that are back and forth are counter offers. They serve to extinguish everything that went before it. And this becomes really difficult because it gets convoluted and messy. We might have agreed certain parts, but there's certain other elements outstanding. There might be some terms that we haven't signed, or that we're not capable, or we're not going to agree to, but we're still performing the contract. We just don't, you know, agree to them. We can't sign on the basis of that, but we're still continuing with the works. And essentially now, this is where we got RTS flexible coming in, to really coming into place, that case I mentioned earlier. You know, just to say that there's no contract because you haven't agreed all the terms won't prevent the redress. The courts really will strive to get an answer, and they will get an answer on those points, given all the facts of the measure on that. So, for example, if the subcontractor submitted its quotation to the main contractor's only response is to instruct the subcontractor to start work, the main contractor would be deemed to have accepted the subcontractor's quotation. And of course, you get the points back and forth where that would actually arise. These are really typical, and it is generally something you see in those areas with, you know, value. But a lot of damage can be caused to either a company or to a project by these particular instances happening. So where there's a continued negotiation and it's apparent from the parties do not regard themselves as bound, there won't be an agreement. So if both parties agree, well, there is no agreement, albeit, that's one of the starting points. But, you know, maybe there is, but in the absence of a binding contract, a party who's carried out work, request of the other, will be entitled to payment of a reasonable sum, as much as they're worth. So that's the battle of the forms. It's prevalent. It's very much discussed by young law students as well. It's something that you can see. But of all of the industries, I think construction, it really is prevalent, and perhaps there isn't enough talking about this. I think that ultimately there could be a lot more education, or certainly discussions about this tendering process of the back and forth all the time. So that companies now know first of all, they recognize that it's happening. And second, once they recognize it's happening, what is it that they need to do to make sure that the balance is shifting and stays in their favor, that they have that certainty as to what they're actually going to contain with that. So letters of intent. So what is a letter of intent? So the real difficulties now, when I'm thinking about letters of intent, there's numerous different case laws on this. And realistically, like, you know, when people look at and they always talk about precedents, which is right, binding, absolutely, especially on lower courts for those decisions. And that's absolutely right. But what we actually look towards is we expect, and most people would expect, that when you have a decided case or a judgment, you're looking really for what's called the ratio decidendi of that. What is the outcome, or what is the big ticket item, that what does it find? The difficulty will be around letters of intent is, why do we get so many different cases giving so many different views on whether or not a letter of intent is a contract? Is it a contract? Does it form a contract? And because we got cases which say, in some cases say, no, it's not a contract, or another one which was sort of a subject to contract, which is the Scan's case at that time. And then we actually have ones that say it is fully fledged. The difficulty with a letter of intent is it doesn't have any defined meaning. So it's really going to be that when a courts have to analyze the contents of a letter of intent, it really does become important what it says, because that will inform whether it is a contract at all. So it's going to be very fact dependent and what's in the contents. So just by a party immediately saying we have a letter of intent should always raise that little bit of suspicion. What does it actually say? What is the contents? And is it an agreement? Is it likely to be held as an agreement at all? Because this is what could happen. There's no contract formed at all. A contractor will be paid only on a merit basis. That's not as easy as it sounds to get paid as much as your work. To run an argument like that, you've got to prove. So you're really got it very much. And when we start talking about sort of supply labor, payment of labor, and getting into that real detail, proof of that goes far beyond just the timesheets as well. So there's no commitment to complete the works, no completion date, no provisions for liquidated damages. All of these things can fall away quite easily in general terms. An interim or simple contract might be formed where each party assumes reciprocal obligations to the other. There might be an if contract, or subject to contract, subject to contract, which is one of those different items that you would normally expect to actually put forward, say in land transactions, subject to contract. But inherently, how does that actually affect? Because we've certainly seen that the details and how one or two different statements can be fatal to the overall case in those points. So a contract can be in any form at all, and we know from the amendments that was made to the Construction Act itself that certainly verbal. Before that, contracts had to be in writing. But I would still say, just because the Act permits verbal contracts, there is, we're talking about a balance of probabilities to prove your case here. So it is, if we talk about evidence like a spectrum On one end, you got very, very poor basis or poor evidence. And on the other end, you've got very, very good evidence. Well, you want to be on the very good evidence point of view, that more likely than not, what you say are the correct course of events. And to do that, you know, when you start entering into witness statements or statements, you know, from those, when you don't have the requisite evidence behind. So clearly, it doesn't take me to suggest that a verbal agreement to carry out £2 or £3 million worth of work is substantially an inferior way than a very well set out statements of intent that are drafted, written, and agreed. So just to remember that sort of spectrum of evidence. There are some exceptions. These are principally contracts for the sale of land, disposition of land, and usually they fall within sort of Section 2, Property Miscellaneous Act 1989. Contract of guarantee has to be in writing. That follows Section 4 of the Fords Act 1677. So like a guarantee has to be in writing for that as well. So executing a contract. So ultimately when we get to it, so we've already found out you don't have to sign a contract to be bound by that. You can, by your conduct, you can be banned, you can perform, and you will still be banned. But the best that can ever be in that instance is a liability of say 6 years, or as if it was underhand. So executing a contract as a deed, company is no longer required to use a seal, and certainly under the Companies Act 2006, it can be executed as director and a company secretary, 2 directors, or certainly a director and a witness. But the terms of the contract, first question is like, what are we going to do? What are the express terms? So like, you know, if we look and we take a very standardized JCT, you know, we've got 9 sections. In that, excluding the minor works, we've got 9 sections. So they're all pretty much laid out. And if you look at each different element, what they actually seek to do. Clearly payment is there, clearly third party, clearly carrying out the works. And termination, albeit termination clauses are not visited enough, given the fact especially that how often relationships actually break down. But the express terms can be in writing or in oral, and there are express agreements. There can be issues regarding the meaning of construction of the express terms, ambiguities, what the, you know, and certainly we've always had that argument, the contra pro referendum rule as well, which hasn't as much favor recently. An express term limiting or excluding liability may not be enforceable, but of course it can be. Like, you know, in certain things, you can certainly limit your exposure to risk, but it would offend the unfair contract terms to exclude, say, liability for, take for example, fraud or debt or injury. And certainly those terms would be void on that point in unfair contracts. So the implied terms as well. So if we need to imply a term into a contract to make that work, so we can imply things. We don't have to incorporate every single term. For example, if we were to go off and incorporate every single term, well, therefore we'd have to incorporate either by reference, or we have to incorporate everything. So the Health and Safety at Work Act 1974, you know, so you'd have these truckloads of all these legislations, or incorporate them by reference. But in certain instances, like for example, the Construction Act will be implied. So parties can't contract out of the payment, but there is a scheme there that if there is a deficiency in the payment regimes, that they have to actually work towards that. So the courts are willing to add terms as implied, establish usage, for example, where there's an apparently complete bargain, which without such a term, the contract would be unworkable, for example. And these are necessary, like these are not by choice, these are not easy terms to put forward, because ultimately there could be disagreement. Where the court is concerned to establish what the contract is, the parties not having fully stated terms, i.e. give the contract business efficacy. Implied terms in building contracts. There are some important terms are usually implied. Such terms require the employer to give possession of the site within a reasonable time and give instructions and information at reasonable times. That follows very closely that, you know, you can't benefit from your own breach, of course. The contractor must carry out the works with proper skill and care, and goods and materials must normally be of good quality and reasonably fit for the purpose. Okay, so now we've got different elements coming through, which we say as a Goods Act. Sales, Goods and Services Act 1982, or the former being 1979. So we've got these different points now coming in, which are mobilized or statutes. There'll be no scope for such implied terms where the matter is dealt with expressly by the building contract, of course, unless it offends. So limitation periods, and this is going to be, it's usually one that's glossed over, but the criticality of anybody who's building their business or planning or understanding what it is. One of the chief revolving themes is that once a contractor, once a party, or once a subcontractor gets a practical completion, that's the matter done. And the only thing left to be resolved is the final account. We do have points about what's called limitation periods, okay, in the 1980 Act, and essentially what the liability stands. So anything that has been a breach, we're talking about sort of latent defects is a great example. It's a very good example, which is a breach. Not apparent at the time. It's not a patent one, but it becomes patent after latent, being a latent defect. Ultimately then, or something occurs, especially in design, we have that period of time, okay, 6 years underhand, or 12 years execute as a deed, etc., or expressed as a statement. And that is actually what we've got to be planning for. So when we talk about entities, if a company has 20 projects completed, well, they have 20 different elements that potentially could produce an issue within 6 years of, so the run on with insurance and how we actually plan for those working forward, what we do with our documents as well, and how we store those. Because 6 years seems like quite a long time away, and I've certainly come across matters which were just under 12 years, actions being taken just before the limitation period of 12 years, certainly peculiar enough when disposition or transfer of ownership and all of these things came to light. We're talking about people's memories, particularly, may not be that wonderful. To go back to the event. So how do we actually protect our documents? And realistically, small companies need to be talking to their brokers and insurance providers about how documents are actually provided for in the event that a claim is made during the subsequent years. So there is a planning point with that. Small companies, regrettably, are not the most terribly wonderful at this item. It is very much a case that the project is completely finished when they reach practical completion, and that's it. And the only thing that's left to deal with is payment. This is not particularly right at all. And this is just for those companies who do want to build, they do want to grow, they do want to be safe, and they certainly don't like looking up at the ceiling at 3 o'clock in the morning. All of these points, rather discreetly as they are, they do matter on those. So a tender inquiry is usually an invitation to treat. It's not an offer, but an invitation to the contractor to make an offer. Contractor's tender or subcontractor's offer will normally constitute the offer. Moving down the line, of course, the contractor's tender can be a valid offer even though it doesn't comply with the tender inquiry requirements. So interchangeable, I'll just draw your attention to the interchangeable terms on wherever to sit in the hierarchy. The time to take action over the onerous contract terms and obligated pre-contract. Okay, so ultimately, when a dispute arises in a construction contract, realistically, how it's resolved is to visit what the parties intended at the time of contract, seek out those intentions by way of fact and by way of certainly the evidence, and to ascertain then what has changed. If it's a breach, who is liable and held a risk for that breach, and therefore quantum can be evaluated from there. Hindsight is a wonderful point on this, but like I started off this conversation, if we took the last 5 projects and any problems that you're to write down to 5 projects, you generally find that they repeat. They might look a little bit different with different people, but ultimately they're the same issues. Terms and how these risks, and this is going to be particularly important over the next maybe a year, year and a half, because we're now looking at a real contracting market. It's very difficult to suggest that subcontractors will now, that all of the different issues surrounding contracting market, all of the different issues of how price slumps are going to be affected, all of the issues that are faced with, that suddenly the increased costs will magically now be entertained and accepted. It simply won't. But we have a real forbearance, we have real issues is that the lower entities will be hit one way or the other, and they will struggle with the costs and the overheads. So now is a period of time that is to prepare. When I talk about risk, I'm deciding, what type of margins are we looking at here? What if an element were not to be successful, can we actually put ourselves back in the position we would have been had the contract been carried out correctly? Do we have a right, and are we sufficiently catered for that point? Are our abilities? Are we looking now at cross claims, cross set-offs, abilities to do those? Are we looking at those? And are we now looking, going into this environment, are we looking at very long payment terms on a project with low margins and inherently full of disputes over values? They are the trigger points for small companies to become insolvent very, very quickly with cash flows. And we're entering into that period of time, and we all recognize that it will be a difficult environment. So these real typical questions now is the time to prepare for those. But what are the options? Not tendering at all. Well, we have to tender for something, but that's the risk-based analysis. The qualifications or the negotiations, and this is it's a skill. It's a skill like any other skill, can be practiced, trained upon, but it really, rather than surviving on the wit or charm of the person negotiating, going in with hard, good, sound positions of first principles and a foreseeability of what are the elements. So when most of these contracts come across my table, often parties will suggest, have a look and tell me what's wrong with it. But it's a very getting into what it must relate to something. It must relate to the business. How does the business perceive risk? And generally that works out very, very well when you know your clients exceptionally well, or certainly my own experience in construction, you can certainly ask the right questions. And having been an engineer and having worked in the industry, you generally will know the right question that have you thought about, or have you X, Y, and Z. The worst thing you can do is really just redline, because you're now in the market realistically where somebody will be signing up no matter what the terms say, and immediately you can exclude yourself very, very quickly. And contractors have been known to do that. Contractors have been known to say, if you come back with any comments, you will be pretty much not in the running. We will go immediately to somebody else. So that we have that conundrum, but it's very much a practice, it's a skill, but understanding what are the trade-offs, how to analyze that risk, how that risk is priced, and what is the likelihood, or what's the foreseeability of an element. So of course, like if you're the only contractor, subcontractor, or that's ever going to be on the works, and I'm talking about something perhaps like demolition or right the way through, perhaps in early stages of groundworks, the interactions or setup with other subcontractors is going to be less than if you're a finishing trade, or if you're cladding, or if you're internal fit outs. So the initial points that an employer should check standard form to be used in its tender. So first of all, are we using the right form anyway? Form needs checking, have the appropriate secondary options for NEC, for example. If standard conditions include bespoke amendments, the whole document becomes non-standard to all intents and purposes. Like, have you actually now changed the whole mechanism on the risk weighting? As such, depending on the extent of the amendments, the terms lose many of the advantages of the centralization. Abrahamson mentioned at one time, going into a dispute, a party dispute, three things you remember: the importance of records, the importance of records, the importance of records. And just a comment on that as well, like generally, and of all of the sort of tracking or the understanding of how disputes are formed and critically how to avoid disputes. And I think that's pretty much one of my major areas for any clients is actually to avoid disputes, real active dispute avoidance. The type of money and the type of problems that long-term clients, and it takes that real work rate to actually avoid disputes, but certainly the balance, the amount of value that it creates to avoid disputes really does become very important. But records, the way I received them, the way I looked them, they come in all many different forms. Quality, the variance of quality really is high on some hands of it, and this is an industry that's awash with data. It's huge amounts of paper, huge amounts of data. How they're arranged and how they're actually collected and how they're formed or how they're from an early stage. And these are habits, and these are just habits, they're traits of how to actually work. So if we're actually going into claim for a variation, a straightforward, simple variation, do we know how to do it? Or is it a case of just alleging that there is a variation and there's an Excel spreadsheet beside it? So it's not a giant leap to actually be able to establish and prove in the balance that a variation is an entitlement for starters, and the quantum flows and how the quantum is actually calculated. And those points, very, very easy. They're part of the standard form. So I'm always surprised. I'm always surprised as well to see how much that there isn't as much debate over the measured account. Most debates, and in fact, like to have a dispute arising on what a measured account is actually quite unusual. Usually it's always the loss and expense. Usually it's the variation account, and usually it's the final account. So if we know those, so why isn't it the case that if most of the disputes are in relation to variation accounts or in relation to loss and expense accounts, why isn't it that we've put our best position forward properly, coherently, and in accordance with what ought to be done? That's an education point. Once that actually becomes part of a culture, once that becomes part of an ability, and I think it's just as simple as this for a lot of QSs or a lot of contract managers who struggle at this point. The real simple point is that they've never been told how to do it. It's that straightforward, but it's all going to be done on it's what you can prove, the balance of probabilities, it's the importance of records. So when we talk about without prejudice, because we're now talking about dispute avoidance, of course, as well. That's where value is. Like now, the prospect of a company, there really has to be something, not quite a miss, for a company who would decide our business plan is to get into as many disputes as possible and to spend as much money on lawyers resolving those disputes. I have never seen that in the business plan. So on that basis, if we're really considered to say that's not how we want to operate, that's not what we want to do, then we must be talking about, well, how do we resolve them? How do we avoid these points? How do we actually prove our position? Because a lot of parties always say, well, we like to get into agreement at the end, final account, we agree to final account. But if they actually stand back and look at the agreement, what they've agreed, what's the quality of that agreement? Have they actually folded completely, accepted it? What's been offered with absolutely nothing of the order of what they're worth? And that's a big question. And that's a question that really is how many bad deals are done or bad agreements are made at a final account stage simply because a party hasn't got the requisite strength to negotiate on that. I, for one, am completely about negotiation, completely about agreements where possible and where it's fair and it's right, but simply put, it must be treated with the same intensity as though you were entering into a dispute with the purpose of avoiding that dispute. And that is critical. So that's why I like the words without prejudice, okay? Because any offer, any negotiation that you are looking to make an agreement without waiving your position in terms of your worth should be put forward on a without prejudice basis. A without prejudice basis doesn't mean that, and I've often seen it, is that correspondence where somebody doesn't want to be held to something that they've said, or certainly they want to, in certain instances I've seen some correspondence marked without prejudice, and the only purpose without prejudice was because they wanted to say some rather distasteful things about the other side, but that's not the purpose of it. In general, it's a cloak, it's a privilege to allow parties to resolve disputes, and ultimately it doesn't, dare I say, go on the record. If you have something like without prejudice save as the cost, well, that's something lawyers generally use quite often, is that if it becomes a matter of cost between the parties. But without prejudice is an important tool to understand. And the more this is used, and especially, but the key point, as in when do we use without prejudice, is that if you are making a concession to your overall position that you think you're worth, so the key word is a concession, on that basis then, you would be probably thinking, let's mark it without prejudice. So it's when you use in context of an existing dispute or agreement or seeking agreement or negotiating. Means without prejudice in the position of the writer of the letter if the terms he is proposing for resolution of dispute are not accepted. If the proposed terms are not accepted, and the recipient will not be permitted to rely on any admissions or concessions made by the writer of the letter. So I'm thinking final accounts here. I'm thinking in around that if we're going into an agreement around the final account, that we want to say, well, I think certain elements of that ought to be worth X. You say Y, well, I'm willing to offer Z. Just to put the matter to bed. Simply put, it's not an open correspondence that you're always willing to accept Z, and that's all you should be worth. So clearly, onerous conditions will always include non-compliance with the Construction Act, onerous amendments to standard forms, use of in-house contract forms, excessive damages are large, extended payment periods, non-payment for unfixed materials, conditions precedent for payment, excessive discounts. Okay, so like we've got this kind of tyranny going on in a lot of these different points. Generally, I would always suggest that good relationships, once they're negotiated out and the format goes, they can generally, the real risk for these are when there's a complete power imbalance, I think is generally when you see these different instances. We've got the owner set-off arrangements, performance bonds and warranties, excessive amounts of withholding or deductions to be made in respect of not providing said documents. Terms suit main contractors' progress, excessive design and coordination responsibilities, unworkable protection obligations, responsibility for checking previous works of other trades, cross claims between different contracts. So I'm talking about a subcontractor who may actually have about 4 or 5 parallel contracts, separate contracts running for the same main contractor, and effectively then one of those doing quite well financially, another one maybe not as well, but the losses from one being offset against the other. So that's going to absolutely deplete anybody's cash flow, and the rules really must be looked towards that. And in any event, cross-contract claims, they really do need express wording, and the wording needs to be quite clear, very good wording. So most loss can be avoided by maintaining monitoring basic routines from day one, confirm start completion dates, record the date and origin of all programs and revisions, notify all delays to the client immediately become apparent. Again, we get very detailed on these points of how we actually then form them, the quality of that information and how that runs through. Certainly the list of the diaries are probably one of the most powerful forms of records that really can be contemporaneous evidence, and what the headings are once it's done correctly, not just about the weather. It seems to be just one aspect that's consistent about diaries is to suggest what the weather is. Recognize variations, and this is the key point, recognize variations and financial claim situations. What are the triggers? How do we know? So essentially, what are the trigger events that we know that there has been an impact on time? So if we're not updating a program for ourselves, and if we're a subcontractor who just ordinarily only ever produces a program to give because the main contractor or client is continuously harassing for one, if that's our only purpose, to provide a program of works or where we stand, well, then we simply don't know what the purpose of the program is. Purpose of a program must be that we inherently know ourselves where we stand with progress of activities and the activities themselves. Why aren't we impacting those with the inputted variations or real-time delays? It becomes a program is probably one of the most potent, most effective tools in all of this, no matter what. But be proactive in recommending solutions to overcome delays and problems, but generally not at your expense. Apply for extension of time as soon as the end delay seems likely. Writing, construction, writing. But one of the major traits that I've often seen in disputes around final accounts and when loss and expense or variation claims come right at the very end is this upsets quite a lot. It goes right to the fund. Expectations are clearly out of the way as well, and the whole point. Ordinarily, and funnily enough, it's actually early raising of claims and delays, but having that pretty much proactive approach with it actually is generally, it doesn't always seem like it, but it's always generally taken very well. That's certainly my experience, because now it can be dealt with. Nothing is more terrible than actually all in the final third, where most of the disputes actually arise, by the way. When you look at all the disputes working through, that's generally where they actually run through. Keeping a daily site diary and include records of labor, names, trades, activities worked, and key events. Needless to say, applying for payment. But what happens if the payment doesn't arrive by the final date for payment, lack of payment, pay less notice? We really do need to be thinking about Section 112. Section 112 of the Act. So if it doesn't actually, the contract doesn't expressly contain a provision for suspension, certainly it's provided for in the Act. Section 112, so 7-day notice. If you, and of course this, like if there's a pay less notice, it won't work. There's a clear dispute at that stage. But if they're in the absence or the amounts that are due on the final date for payment haven't been paid, realistically, parties should be thinking the day after to issue that 7-day notice to suspend works. It's probably one of the most effective tools for subcontractor, especially when your works are critical to the performance overall of the contract as well. These routines should be utilized in a cooperative and willing way. Look for solutions to problems. This does not mean, however, that you have to be naive. So we're looking at the date, weather, visitors, labor details, subcontractors. I go quite a lot further and very detailed into these points. The areas, completions and handover access. What drawings? Have those drawings that we're actually working to, are they a T3 version or are they a C3 version? And if that's the case, what we tender on, what the pricing that's in our documents, in our bill of quantities, what in effect is the change? So how do we know what drawings have actually been priced in the bill of quantities versus what's actually being worked on at the moment? What changes are there? Are they minor? Is there actual value? Are we actually going to do a completely different project? And it should be, we'd be working to tender drawings anyway. So the updating and understanding those changes and how they actually, there are sanity checks. There are variations received, the key events, for example, client visits, meetings, health and safety, accidents. A high proportion of payment problems are self-inflicted, and we must be quite upfront about that. And the time to deal with payment is at the initial inquiry stage. What we need to be aware of, what's the interval between the commencement and first payment? When is the due date? We need to be able to calculate the due date. That's not the date you get paid, but when is the due date? What is and how do we calculate it? Do we really want to be going back to the scheme and trying to calculate when the due date is. What's the duration from the due date to the final date for payment? Interestingly enough, that like most due dates are actually calculated in accordance with commencement. Now, if that's correct, most QSs that I still talk to now seem to believe that all projects magically start on the 28th or near the end of the month on every given project for when their valuations are due. Simply can't be correct. We're not that consistent. But are we getting our due dates right? Because if we're not getting our due dates right, we might be not entitled to payment on that basis. So these, again, are education points. They're pretty much to understand what is it that we're actually contracting to, because this is ultimately what it's all about. Is a payment linked to a main contract certificate? What's the timing of the notices of payments due and notice of withholding? But simply put as well, what is everybody else's payment? That's not something to be nosy about, but I'm suggesting that if you're a subcontractor, that a contractor is being paid by the employer is invoicing a fund, shouldn't we realistically know what the overall framework or how everything is working? You're one cog in that wheel per se as a subcontractor. Certainly other parties' relationships, albeit you're not in contract and you don't have any rights to sue on those contracts, the awareness to understand what you should be contracting on yourself. Who values the work and how often are on fixed materials on site and off site to be paid for? Is there a vesting certificate? Is retention title clauses? When is final payment due? How do we calculate that? What's the retention percentage and when is it reduced? When is there a final release date? How long is the defects period? Is there a set-off clause? Is it onerous? Ensure any discount is cash discount. Are the terms compliant with the Construction Act? Ultimately, as well, we're actually asking the question then, how do we actually come to the realization of the final statement as well? Ultimately, we want to be saying, if it's difficult enough to get the first half of retention released, but if that's difficult, well, this last half of the retention is extremely difficult. So now we must actually look to see how is retention treated as well. But when we claim for delay costs, most subcontract conditions provide for payment for loss and expense, for example, prolongation costs. However, entitlement strictly depend on the following. The reason for the delay must be such as to give legitimate entitlement under the terms of the subcontract agreement or order. The subbie must make written application for loss and expense as soon as likelihood becomes apparent. He must be able to provide evidence in regard to the circumstances. He must demonstrate the nexus of cause and effect, for example, a clear link between each notified event, delay, and resultant loss and expense. He must state the contractual basis of his claim, for example, which clauses are relied upon and common law applied. These are points that we'll repeat again and again in each given contract. If we are a business that wants to survive the coming difficulties that we face, well, then these education points become incredibly important. Because now that we have this information and we have these techniques, we can now apply that to each and every instance. There are a number of loopholes within the Act. Exploited payment, extended payment periods, now paid when paid, has been outlawed. Many contractors are imposing lengthened payment periods. Set-off notice. The Act does not prescribe a period of notice. Some contractors state that only 1 day's notice prior to final date for payment. Obviously, totally inadequate, can have disastrous effects on subcontractors' cash flow. Try to go back to the instance of Carillion. 120 days payment terms in many instances wasn't unheard of. That would mean of the order that sometime in around January, February, you application certified, payment is due sometime in May. All the way through, you might have invoice factoring during that period of time. 1 day before final date for payment, a pay less notice is issued, perhaps even saying that you're owed remarkably less than you're expecting, or maybe nothing at all. Even if there is a valid dispute, an adjudication could take a month and a half, potentially certainly up to 42 days, and even then enforcement might be 2 months thereafter. We have now ended up in a period of August and we still have not been paid. For any small entity, 3 or 4 times of that occurring will put significant pressure on any entity at all. These are the positions, and these simply are what can be the effects. Cross set-offs. Contractors include cross set-off from one contract to another. They can even extend this onto another company or another group. Future set-off. Contractors have been known to impose the power of offsetting future costs likely to be incurred, but based only on their own estimates. There's normally no mention of repayment if the estimate proves to be excessive or invalid. Deemed to agree 40-day, 5-day period. One major contractor includes a deemed to agree clause whereby the parties are deemed to agree, regardless of actual timescale, that the duration of the subcontract will be construed as less than 45 days. This constitutes a gross abuse of the Act, designed to hold on to money rightfully due to the subcontractor as he signs away his entitlement to monthly payments. But that is particularly poor. Notice of suspension. The Act prescribes that not less than 7 days under Section 112, notice should be given by a subcontractor in the event a non-payment of sums notified as due extension of this period is becoming more common. Pay when certified, now pay when paid has been outlawed, accepting insolvency. That's Section 113, which all subcontractors should be really aware of. And certainly if not, do email me if you're not aware. Contractors are fixing the date of certification by the architect under the main project as the due date. The subcontractor has no knowledge of when this may happen, which leaves them at the contractor's mercy, open to pay when and if certified. It can mean that subcontractor could potentially lose his money. Certification is withheld due to contractor defaulting in some way. So when we talk about looking towards adjudication, the satisfaction procedure is common ploy prior to a subcontractor giving notice adjudication. Some clause will prescribe a fixed period, for example, 2 months, completely delaying it. Joining in clause. This clause obliges the subcontractor to join with the contractor against an employer if adjudication matters are related, again designed to hamper the subcontractor's right to prompt an adjudication. Final and binding. This clause imposed by the contractor in respect of decisions will prevent an adjudication from reopening decision. Practically, this can mean a contractor can refuse an EOT or set off large sums from the subcontractor, leaving subcontractor no recourse to adjudication. But ultimately, we must be looking at these points about dispute avoidance, because if we take those skills, we take those elements, because the foreseeability is that they repeat. As I said, and I've repeated again, we're going into a very uncertain time. What mostly will happen in these instances is the parties who've prepared, who understand the environment that can actually prepare for that. Okay, good evening and thanks very much. Thank you.
Okay, thank you, Henry. That was great. We've had a couple of questions. Someone asks, is a letter of intent the same as an instruction to proceed?
It completely depends on the wording. That is as simple as it sets out. So an instruction to proceed is exactly that, an instruction to proceed. But an instruction to proceed with what? It would need clear identifiable terms with what it is, for how much duration, how that all fits in. It's very fact basis. So a letter of intent, of course, is on its ordinary level would be to suggest we intend to enter into contract with you, carry out these works in the meantime. But you know, what is it that you're instructed to proceed with? And again, what are the elements contained in the letter of intent separately? Very fact-based, very much dependent on the wording. So concentrate on the substance rather than the form of that for both of those instances.
Okay, and then someone else asks, what happens if a contractor won't pay first 2.5% retention as they have not had theirs yet?
Completely depends on the wording, and I've often seen clauses which actually deal with retentions. So the most common part would be, well, retention is only released when practical completion is for the whole project, as opposed. That's really something you must try and avoid. It must be practical completion of the actual contract that's in play specifically. So in that instance, so really narrow down on what your contract is, and ultimately what is the nature of the retention sums being held under that contract itself, not to be tied in with other clauses with other contracts. That's for starters. If indeed, okay, that there is a clear point in your own contract and they simply don't release in that interim position because of practical completion, you should be really looking at applying for that release. If they don't, well, it's a clear dispute. And the first warning would be to say that there's no good reason. It is a contractual provision to release usually 2.5%, whatever it is, or 1.5%, and half the amount anyway. And ultimately, what is it that is going to be called for if dispute if it hasn't been paid?
Okay, they've just come back and said further to the above. Is that not them not paying the first 2.5% retention? Is that not basically paid when paid?
Yeah, essentially, that's like, no, like you can't. It is unique to your own contract. So if a contractor is suggesting, well, we haven't got our release yet from upline, I'm afraid to say that's their issue. It's this particular contract, the subcontractor, that it's released upon. So that's nothing to do with us. We are only concentrating on our contract. It's 2.5 and we'll have it now, please. Thank you.
Okay, can't speak this evening. Are cross-contract set-off clauses legal?
Okay, so in terms of contracts are all separate. So what the difficulty with the cross-contract set-off clauses, you can actually draft. You can actually draft pretty much by way of agreement to bring those into play. It needs really clear wording. It needs really express agreements of how you can actually offset against another performance. Because ordinarily, it's a different contract. So it's completely separate. There's no immediate right to do that. But with express drafting, following through and identifying, and it has to be careful drafting, it has to be right, but then it can. I would certainly really look out for those. It's not in your hands at a certain point, because you can have some projects that are running quite well. You might have those projects that are not running well at all. So the ability to marginalize that and offset and claim off something, another project, really could be detrimental to a subcontractor. But the wording has to be very, very well drafted. It has to be very much done the line. Okay.
And then one final question is, if a trade contractor refuses to comply with the site instruction under a JCT contract, for example, failing to provide all the necessary resources to carry out additional works, can the employer act on either one or both of the following? One, put them on notice and set off any costs incurred to the trade contractor, or two, call on a performance bond after a breach has materialised.
Yeah, okay, so in terms of, if we were to take something, so let's consider what type of contract we're actually looking at this moment in time. So first of all, we've got to be very clear on what the contract is. So if we take JCT, for example, all instructions are to be in writing. There are, I'm choosing JCT because it's a little bit more standardized and it's a bit easier because the words are clear. The difficulty that you have is that a contractor or subcontractor, in this instance, will stay with the terms. A subcontractor is to comply with the instructions. Now, JCT doesn't over-explore everything here, and it doesn't reach to its very end. But if you don't comply with the instruction, that's a breach of contract. And there are only really narrow grounds that you can actually, dismiss an instruction. And there's two different instances of that. First of all, pre-practical completion, you have to comply with the instruction forthwith. And after practical completion, it's within a reasonable time. And there's very good reasons why that is, because parties have vacated the site, so they can't forthwith. The difficulty is that if you actually don't comply with an instruction, it is in the hands then that it is a breach. And then the parties are free at that stage. If loss has been suffered from that breach, then at that stage, you can actually allege those losses and start setting off those losses because of non-compliance of that breach. So that's ultimately where that goes. So if we're looking at design would always have that kind of element as well. It comes in with instructions of those points. So ultimately, your ability, you must comply with and really are very narrow points on not to accept. You would be actually saying it's substantially different, as very much out. Health and safety might be those different points. If there's going to be a clear breach that you're continuing to put forward a breach, there are different instances as well. So it is a breach by not complying. If there is a breach and losses occur from that and they're not too remote, then of course losses can follow from that as well.
Okay, that's great. That I think is all of our questions. Oh no,
there's just one. There's just one there. So can you omit?
Yeah.
Can you omit large section of subcontract works if they are performing badly, assuming there's an express clause in the contract? Okay, so one of the elements is you cannot omit works and give it to others. That's a fundamental breach of a contract. So the ability to so in a variation clause, in general variation clause, you can omit works. But what you can't do is omit works and give it to others to perform. And that would be a repudiation on that point. But this is different. This is saying that the works are being performed badly. So the express clause really that you're going to here is you're now into termination. So essentially, if the works have been performed so badly, you are now talking about, say, for JCT, for example, you're invoking clauses that are relating to specified defaults and providing notice that within a set number of days that the works have to be corrected. Otherwise, it would give rise to termination. So that's that's really where this question goes. So what can you do about it? You're actually heading into a specified default and exercising on that specified default at that stage. That's the clearest way forward for that.
Okay. Well, thank you very much, Henry. Thank you everyone for turning up this evening. And we hope to see you again very soon. If you've got any specific questions for Henry, his contact details are on the slides and on the website. And I know he's always delighted to answer any questions you didn't particularly want to bring up during the course of the seminar. So thank you very much, Henry, and thank you everyone, and stay safe. We'll see you all again soon.